person, and then there's a guardian of the estate. Person would have to do with living relation, you know, with a child, it'd be living in their house, and you could have someone else that would be guardian of the funds. And the guardian of the person is most common. But when you're nominating somebody, they may not be the same person. Yeah, if you don't have a will, it gets kind of crazy trying to go through intestate succession. And they're not that difficult to do in terms of people talking about estate planning these days. It seems like the major discussion is that, oh, pour over will and the other wills have no purpose, but they really do. It identifies a lot of things, and I'm speaking of the will that's not pointing over to a trust. A nice thing about it is, say if you have somebody in your family you don't want to get any of your assets, if you don't have a will, you don't have a choice. And frequently, like siblings or different people would end up getting a bequest when you would not have intended that. And I think everyone should have a will, even for people who are in their 20s and 30s. Even if they don't have any assets, you never know when you might need one, and they're not that difficult to make a simple will. So what would be the situation where it would be good to have the will as a centerpiece for your estate plan? First, it would be if you do not own real estate, you don't have young children, or they're now self-sufficient, or if you do have young children, that you make provisions for that. And it's not just finding a guardian with the younger children. It's not part of a will, but you should also have term life insurance to guarantee that they can maintain the lifestyle that the children are accustomed to. And term life insurance is not that costly, especially for younger people. A problem that comes up, and since more and more people partner up and they're living together, not being married, there can be a problem with bequests on it. If you don't have a will that gives things to your partner and it has to go to intestate succession, your partner is not going to receive anything, even though they feel that they own everything or half of everything. That may not be the case. So that should be considered. And a will might not be the best thing for complicated assets that have a lot of moving parts, like a business. We've had cases where they've had music rights, all these different songs and all these different royalties coming in. A will wouldn't work as well, nor if there's quite a lot of rental property. A will may not be the best tool. So I already mentioned the life insurance. I prepared this little worksheet to kind of demonstrate how the flow chart goes with a will and probate. Probate has got a bad reputation. Everybody says don't do it. So this is kind of like a decision tree. So the first person example, they have a small estate, less than 166,250, which is the break point when you would need a probate. And since they have less than that, a probate's not required. And there's another procedure which we'll talk about called the small estate affidavit procedure to transfer the assets without a probate. The second item on the decision tree is if your assets are greater than, got cut off here, but 166,250, And then you do need to go to probate to transfer those assets. And when we're talking about probatable assets, we're talking about usually real estate, investment accounts, cash, personal property, but not in the computation are pension plans, life insurance, or annuities. Those are not part of the computation, nor are accounts that have a designated beneficiary, like a pay on death account. So the third on the decision tree is the total value of all assets, probate and non-probate, of the decedent. And I spelled value wrong. Oh, lucky I noticed that. If the person has more than 11,580,000, they should probably have a trust, obviously, and this ends up creating the need to file an inheritance tax return. And that only ends up being about the top 1% of the population. We're still doing inheritance tax returns, on occasion. So they're still out there, but they're not that frequent. And I've included this form in Exhibit 6. The entire form is there to assist you in listing assets, and it's by categories, and there's headings and there's footnotes that explain how that works. Okay, other ways to avoid probate or have lots of assets in pension plans, including the Roth IRA. These are already in a trust. It doesn't seem like it, but your IRA has a beneficiary, you're the settlor, and then there's a custodian or trustee, and that's the vendor on the account. And those usually they always stay out of probate. And usually it's not a good idea to put them directly, aim them if you have a trust, but they're okay to go to the named beneficiary individuals. Other types of assets you don't need to probate, registered vehicles in California. We don't bother putting them in the trust if there is a trust, although we're talking about wills tonight. There's a small asset affidavit procedure with DMV that's actually kind of lax. I mean, you come in and you have a death certificate and you say, I'm the person, and they give you a title. I mean, what's going to stop somebody? You got a Ferrari and I'm the survivor. Other things that avoid probate: manufactured homes, vessels, meaning boats, armed forces, pay, salary and compensation. So those are some of the ways to avoid probate. I'm talking about avoiding probate. I never really defined it. Probate's a procedure where the court supervises every activity of the estate administration. It is unbelievably tedious, complicated. The pages and forms you have to fill out are unbelievable, and they seem to never end. People say, oh yeah, attorneys make a lot of money on probate. I don't know. There is so much work to do in the probate. That's really questionable. It takes quite a while to get through probate, and it's a constant back and forth of filling out papers, having the court probate examiners give you tentative rulings on things that they would like to have changed or improved. So that's a simple overview of the probate process. In this area of using a will, if your assets are less than $166,250, you can use a small affidavit procedure. And in the exhibits to this class, I've included a model form that appears like a judicial counsel form issued by the courts that can be used for transferring personal property or things less than that value. We just had one recently. The client died, his surviving partner tried to get the bank accounts and they wouldn't deal with her at all. And in the will and the trust, she was in charge. And so we filled out the 13100 declaration, she notarized it. And part of it says that if the bank or institution does not comply with this request, the institution is going to be liable for all the costs and legal fees to get a court order to make them comply with it. And in this circumstance, they decided that they ought to turn over the account, which really was the proper thing to do. Another way to avoid probate is joint tenancy. Some people call this the poor man's estate plan. I don't recommend it. It's got some serious drawbacks. The first of which is people don't realize it and they try to dispose of their property in their will or trust, and a will or trust has no impact on joint tenancy. It goes to the survivor automatic. They call it a court by an operation of law. But the real downside of joint tenancy is when one joint tenant dies and the other receives it, the property, the other half, they only get a half of a step up in basis, which means for tax purposes, if they sell the property shortly thereafter, there's no capital gains. For husband and wife, when there's property that's community property, that's even better tax-wise because both halves of the property get the full step up to market value, which is important because if it's a rental and the depreciation's higher, and if you sell it later, the gain's less. When you have a situation where all the assets are community property for a couple, and whether they have a will or it's intestate, there's a procedure called a spousal property petition, which is an abbreviated, it's almost not like a probate, it's more like a petition and evaluation where all the assets go to the surviving spouse and it's not all that burdensome. As you probably know, revocable trusts end up avoiding probate, and that's the purpose of them.
Rex, can I just stop you for a second?
Sure.
If anyone who doesn't have the material, it's in the chat room. If you go to the chat room, I have been sending them individually, but there is the materials in the chat. They can download them for anyone that didn't get them today. Thanks.
Okay. The next item that avoids probate is multi-party financial accounts. We had one not too long ago where there were 3 owners on the account. It was outside the trust that we didn't know about, and one of the parties died and the accounts went into the name of the other 2 owners, similar to joint tenancy. So that's a probate avoidance technique. Another one is to sign up with your financial institutions with a pay on death account. It's just an agreement with the financial institution. When I die, I want my daughter to have whatever, this account or this stock account. And it works well. If you have any other ideas or things you want done with the property, it's kind of done really fairly quick. If you want to have some what they call dead hand control of what happens to the assets, you're probably looking at more like a will or a trust. California in 2017 came up with this California pay on death real estate deed. And it does avoid probate, but it has some serious defects in trying to use it. I don't recommend anyone using it because the person who receives the property also becomes liable for the personal debts of the decedent. If it,
Really?
yes, And on the house, you receive it, and then it's subject to a 3-year period where it can be challenged and maybe brought back into the estate. It's, I don't know why they did it the way they did. But I'm not recommending it. It's too dangerous for my view. Another way to avoid probate is just spend all your money before you die, give everything away, die penniless, fat, dumb, and happy, and guaranteed there's not going to be any probate. But that's not recommended either. That's too much work for me. I can't stand the stress.
I have a couple of questions, Rex.
Okay.
Let's see. From Anne Marie, are manufactured homes on foundations that appreciate as real property included in those that can avoid probate?
I'm going to step back here. Okay, so in this section, it says manufactured homes, mobile, commercial coach, these things registered with the California Health and Safety Code, and gives a code number. Now, that means movable. And I know a lot of manufactured homes now are not movable. They bring them in on a truck, they put them on foundations, they glue them to the ground and hook up the pipes and electricity. I don't know the time period, but I would assume that at some point they won't be registered under that agency, but I don't know the real answer. But the definition of real property is the land and anything affixed to the land. Now, if I see a property with a foundation, piping, electrical, everything else, I think that's part of the real estate, and I don't think that that would avoid probate with some limitations.
Okay, one more.
Sure.
What about a homestead? Does this avoid probate?
Homesteads have nothing to do with probate or not probate. What those are asset protection devices. And what you're really working with is the title of the property. So if you have a homestead on a property, you have it in a will, it goes through probate, the homestead disappears when it's distributed to the beneficiary because they didn't file that homestead. But it's not anything to consider by itself. It's similar to a mortgage on a property. If you have a mortgage on a property and it goes through probate, the beneficiary normally gets it with the mortgage too. Same thing with a trust. When they distribute property and there's a loan, it goes with it. So it's just a part, but nothing else to treat separately unless the beneficiary thinks it's important.
Okay, and then a person asked, can you explain the dangers of the TOD, the transfer on death, in more detail? I assume she meant the transfer, or the person meant transfer on death of deed, the one you just were talking about?
What I said on it, there's a lot of downside to it. I have a whole presentation on it that would take over an hour to go through, and it's a little bit more detailed than I think is necessary. I just wanted to give you a heads up that it has some serious defects, not to train you in it. You can look into it, but it does avoid probate, and that's the only reason why I included it. I don't know anyone who's using them, and if they do, I would imagine they don't know the risks, but unfortunately, I can't take the time to go into all the depth that you would like.
Okay, that's all for right now. Thank you.
Sure. Okay, so we're still trying to avoid probate. There's an affidavit procedure for small real property. worth less than 155, 425. So that's not a probate. We're doing one now. One of our clients found out that her dad had left a lot in Northern California, and she's the only beneficiary. So the procedure is you fill out an affidavit of property of small value. There's an example of it in our exhibits at the end of the material. And you have that notarized. Then we had to go to a probate referee to get the value of the property. Then with those two documents, you bring it to the court clerk where the person lived. In this case was San Jose. And so you just file it, get a court stamp, and then after it's been recorded in the court, not a hearing, then you bring it to the county recorder. In this case, it was Shasta County, and record it, and that is the new title to the property without a real probate. Yeah, that's the Judicial Council form, the DE 305. Judicial Council is the agency that decides on what forms are mandatory or optional for the use in the courts. And speaking of Judicial Council forms, I've included several different form numbers to be in line with the theme of avoiding probate. So, and I've given you a link there to find the forms. So probate has a maximum fee schedule, and I hear people say it wrong all the time. Said that's what it costs to do probate. Well, the statute said it's the maximum. It doesn't say it is the fixed fee. So you can negotiate with a law office to do it for less, hourly, or something else. And it is the amount for an average or a general straightforward probate. There are other things that are considered extraordinary items that go on top of that. For example, if someone's doing a probate and they have to sell 10 rental properties, those are considered extraordinary items that go on to this fee schedule. So if you had a $2 million estate, this came from an internet site. There's a bunch of them on the internet to calculate this. They're pretty common. So if you had a $2 million estate, first 4% of the 100,000, then 3% next 100, 2% of the next 800,000, and 1% up to 9 million. And so you've got $33,000 as a minimum probate cost plus filing fees. Any court document you file now, $435. It seems a bit high to me. And that this example, this is saying for the attorney. And the other half of it is the executor who's named to administer the probate also has the right to claim that amount. And if the executor is not a beneficiary, it might be a good idea to claim that amount. If the executor is also a beneficiary, usually you find that they do not claim anything for their executor duties, because when you claim that, it ends up being taxable income. And when you don't claim it, you receive it as a bequest that is not taxable. So that's good to know. This is our former good probate judge in Contra Costa County, Judge Don Edward Green. And I was surprised when he said it, but he said, if probate is the worst thing that happened to you in life, then you've lived a blessed life. And I thought about it, you know, everybody says how bad it is, but one thing that I like about probate compared to trusts is, from my viewpoint, I end up hearing about a lot of trusts where the trustee takes assets from the trust inappropriately. And I don't know what percentage, but that happens way less on a probate because it's all court supervised. Okay, some of the history of wills, it goes way back. I realized, you know, when I was doing this, people have been dying for a long time. I mean, wow, ever since the beginning of time. But at first they didn't have wills. They had everything going to the family. And in Greek law, they did not allow slaves or foreigners to have any kind of will. And they had certain people, the male children could get a bequest, but the daughters couldn't, unless the daughters got married to the beneficiary, which I didn't understand. And sometimes the wills had to be witnessed by several witnesses, not just one. Then the Romans got involved, and they started out doing wills by broadcast. In other words, they would go to the public square and read the will out loud, and that was the will. And it was made in front of 7 witnesses. That is called a non-cupidative will, however it's said, without Cupid. And it's not really allowed in any jurisdiction. However, some courts will allow it if it's an unusual circumstance, like a battle situation or something where death is imminent and that's all they had was verbal before they passed. And it's being civil law, some of the jurisdictions don't allow you to make up your mind who gets your property. They've already got a plan for what part of it is. But in most of the ancient world, people would go off to battle, and that would be when they would be considered ready to make a will in case they didn't come back. In law, in general, there's 2 types of jurisdictions. We live in the United States called a common law jurisdiction, where court cases are important. And a case that is decided once in a court, then the other courts need to follow that case in a similar fact pattern. And I like it. It's makes sense to me. The other type of jurisdiction is called civil law. In those, they only read the statute. The cases don't mean a thing. And in civil law jurisdictions, they have what I think is an unsavory aspect quite frequently. They have a forced estate, which means you don't get to decide on those assets. And then there's the free estate that you can decide. So that does happen, and it's divided into shares for the spouse, and the free estate goes wherever you want. If you've studied law and heard the word dower and courtesy, those are some of the terms that they're built into our law. But civil law jurisdictions, for example, France, Italy, Spain, Arabia, Japan. If you move to one of those jurisdictions, I would consider it seriously. The English law kind of evolved more towards our system. They came up with the term legacy for personal property and real property as a devise. It's a distinction nobody cares about anymore. And Roman law, the will took effect at the time of making it, so you might have problems changing it. In English law, what we have is a will only has any effect at all at death. Dying intestate, there's quite a lengthy process. This is some of the word history of where testate and testament came from. And when someone dies without a will, you have to look up on a chart of consanguinity, And it's interesting because Latin, Spanish is sangre, which is part of that word, and con is with. So it ends up being blood relatives in that analysis. So if you don't do a will or don't have a trust, the state will have a will for you. And this is how it's determined. And I was pleased to learn this. I didn't know it before, and I was, figuring out how this thing, I've seen the chart forever, but it's always been a little bit confusing. But this version is understandable to me. So you start out with a decedent, no will. And try to stay awake, Miriam. And a decedent right here. And then what you do is you first look for children, if they have any. You go until you find people to absorb all the estate. Children, grandchildren, or great-grandchildren. If you found none, then you come back out and you start this next column. You look for the parents, then siblings, then nephews, nieces, and you go down this column. And if that doesn't work, you go through the next step. So it keeps going. We had one probate that we did, they had 50 beneficiaries all over the country. And boy, it was like, it was really amazing. But it does get complicated, but this is the estate plan if somebody doesn't plan on their own. So probate generally is considered a waste of time and money, although there are protections with it from having the judge look over things. In its simplest form, a probate, if you think about it, is the problem of trying to get a signature from a dead person. They're not able to sign anymore. So who in the law is going to be able to let that happen? Well, it's the probate court. And they supervise it for the benefit of the beneficiaries. It does take a long time, 10 to 18 months, sometimes longer. It's expensive. There's some benefits of having the probate. One is it cuts off liability to assets. There's a procedure for creditors, and if they don't claim, they don't get paid. Or if they claim and get rejected and the judge agrees, then the creditors are cut out. There's a type of will called a testamentary trust. And I knew one lady that worked well for her. She had a young son, who was about 10 or 12, no other relatives around, and nobody really to act as executor that she knew or trusted. So she created a testamentary trust. If she was to pass away, then the probate court steps in and makes the trust, but all the funds are under court supervision. And usually they require a bond to protect the assets. One thing that I see a lot, and I kind of object to people talking about trust, is I think they oversell the trusts because they say, oh, it's cheaper, you can do whatever things. But from my view, when I hear a lot of situations where the trustee has taken a large amount of money from a trust where they had no court supervision, in reality, the end result is the trust cost way more than a probate. A probate, that probably wouldn't happen. So that's another benefit of a probate. It's not that I like doing them, that's not it, but I'm just talking about the procedures and the cost benefit. This item here is really important, and it's so subtle that most people would probably miss it. So you have somebody and they're elderly or infirm, and they live in a nursing home, and it's not uncommon to pay $5,000 a month. And if they don't have much cash, even if they have a house, Medi-Cal will pay that rent for them as long as they live. We had one client who was paying $150,000 a year for care. But with the Medi-Cal, what happens is that when the person dies and they have their estate in a will, the California Department of Health Services puts a lien on the house and other assets and does, we call it a clawback, where they take the equity in the house and the money to pay back the state for making those high nursing home costs. And we used to do house trusts where it would stay out of Medi-Cal chargeback. But then in 2017, they changed the law, and for somebody in nursing home, maybe they've got Alzheimer's or whatever, and if they have property, it's important to make sure their property's in a trust, because the law now says that if a person is getting Medi-Cal for their nursing home costs, and when they die, if it's in a trust, there is no clawback. So this can be huge. Some of the costs could end up being $800,000 or more for the cost for the nursing home. So just keep that in the back of your mind. So now we're talking about minors. Kids can't have money. They cannot inherit more than $5,000. When we're in that situation in a probate, the first thing the probate court does is put the money in a blocked account until they're 18. The probate court doesn't even trust the parents. They think the parents might take the money. So it goes into a blocked account and nobody can touch it without a court order until the child becomes 18. So another way, if a gift of over $5,000 is to the child, is that you would distribute the gift to their guardian, parent or guardian, to hold the money. Sometimes there's a more of abbreviated procedure if it's a little bit more than $20,000 for a guardian to be created in the court. And a guardian is basically court supervised in the care of someone. Another procedure you could use is the Uniform Transfers to Minor Act. So in your will or trust, instead of giving it to the minor directly, you give it into this, they call them UGMA, Uniform Gifts to Minors, or UTMA, Uniform Transfer to Minors Act. And then it can be held that way because an adult is in charge of the account. We saw one case where the parent didn't want the kid to have it, and it got up to 30+ thousand. Kid turned 18 and went down to the bank and just dumped it out. It was supposed to be used for buying a house, but didn't happen.
Can I ask a couple of questions that we have in the chat room?
Sure.
Okay, Stacy says 155K or 55K. I'm maybe referring to the small estate affidavit. So I think maybe that's what Stacy meant. So the amount is $155,000, the cap, if the small estate is less than that?
Okay. The small estate affidavit procedure under Probate Code Section 13100, I do have a sample in the exhibits.
Okay.
What she's quoting there is it for the longest time was 150,000. And the beginning of this year, January 1, it has been increased to 166,250 of fair market value of assets that would be probated, not including pensions, not including life insurance, not including annuities, or not including assets that have a pay on death. So it's a larger dollar number. Now, the other question that comes up with that question was right around the $55,000 level was for small real estate. And that was a completely different procedure. If you had a lot that in California, it's kind of hard to find them less than that, but we have one going. So hopefully that answers the question.
Okay, is there a particular training you would recommend to help clients with probate matters, or is this only for attorneys?
Unfortunately, I think probate ought to be left to attorneys. There are so many details. And for a client to go in and, first of all, they're like a babe in the woods. And there's this huge stack of paper. And it's all written in, seems like Old English. And whenever you try to do something, oh, you left this out, you left that out, you left this out, and pretty soon the clerks are getting short with you. And although they try to be good, and it's difficult for someone who knows the probate procedure because they are extremely, let's say, quality control is the word I want. What happens is you turn in all your papers and then you get what's called a tentative ruling. It's like getting your papers graded by a teacher and they come out and say, you forgot this, you forgot that, you forgot this, and where's that, and this and do that. And if you do nothing before your next hearing, that's the decision you're going to get. Take care of this list of things. But unfortunately, and I'm not saying it just because I'm an attorney, I just don't think the average person has the time and patience to do that. It can be done if somebody wants to take a lot of time and read, sure. I mean, it's not prohibited in this state. Some states it is, like Florida. So, but I don't think it's a good idea. It'd end up being a whole lot of frustration.
How fast can a judge approve the right for the assigned executor to be able to sell a house during probate?
Okay. So what you end up doing, we just sold recently a couple houses in Oakland. And what happens is you put the house on the market. Now we're doing auctions because we get more money, or just leave the bidding open for 2 weeks to let bids come in and get the highest one. Then you take your contract from the buyer, open escrow, you file court papers for approval in the court. How long is that going to take? Well, before COVID-19, we were looking at 4 months. What it is today, I can't tell you. A lot of the courts are running at partial capacity. And then when your hearing comes up, then the property is, the general answer would be 5 months if everything's going well. The other unique thing that happens is when that hearing occurs, the law wants to get the highest money or the most money for the beneficiaries. So there's an overbid procedure. And we had a buyer all ready to buy, and they just really wanted this property. And then on the day we come in to get it approved, somebody walks in with a little bit higher offer and they took it away. Anyway, but the answer is about 5 months.
Excuse me. Does Medi-Cal cover the cost of nursing homes if the person has a trust, since having a trust does not allow Medi-Cal to recover their costs?
Okay, for Medi-Cal, you can have a trust, and I would recommend you have it for your house. Medi-Cal is very particular on how much cash you have. I understand that you can have no more than $2,000 of cash on hand. But that is what I was saying about the new law from 2017 is you have it in a trust and the person runs up these high benefit payments, and then when they pass away, Department of Health Services looks and finds out, oh, it's in a trust, and they don't charge that back.
Okay, Stacy says Michigan Medicare has a 5-year look back So anything done within the past 5 years has to be reversed or paid for that time. Does California have the same 5 year? But isn't Medicare and Medi-Cal something different? Aren't they different?
Yes.
Yeah.
Medicare is the federal version, and Medi-Cal is the California flavor of Medicare.
Right.
And there are some differences statutorily because California doesn't want to do anything that looks exactly like the feds. And I have never heard of a 5-year chargeback. One of the things you hear about are, and this may be what the question relates to, is say you've got a lot of assets and you want to qualify for Medicare, so you give them all away to your family. And then the next day you go down and sign up for Medicare and say, oh, I don't have anything. You know, don't look at my kids because they've got everything. But, oh, yeah. So that's not allowed. And in those circumstances, there's a 3-year look back for transfers to qualify in California.
And Stacy clarified the reason that Stacy asked about the 55,000 opposed to the 155,000. Stacy said that the material said 55,000, and I think I saw that. So sometime you might want to go back and look at it.
Yeah, I remember seeing that also. But it is more towards the real estate affidavit. And if it's between husband and wife, it's a simpler procedure. Do we have another question?
Well, this one says, why are we having this class if you don't suggest probate by LDAs?
Why are we having this class? Okay, this class is not for probate. It is about wills. And wills can go a lot of different directions. They're frequently part of an estate plan. And the way I see it, that everyone's going to pass away sometime, so they might want to, for their own personal use, learn about the details of what might be better for their own personal estate plan. And it takes a while to absorb a lot of the details about what's in a will, what's in a trust, what's in a durable power of attorney. So I did not say that LDAs could not do probate forms, and I did not imply that. LDAs can fill out probate forms and give them to the proper person, and then they're on their own. So, but it's a different thing. They're the customer has decided that I'm going to take this on no matter what. And when somebody asks, should somebody take it on, I say no. But that's a general recommendation, and there's a lot of people that aren't going to get help from anybody. And there's a huge amount of pro pers in all the courts these days. So hope that answered it. So what's required for a valid will? You have to have the intent to make one. You should revoke prior. And I hear this a lot where people advise, oh, just keep one copy of your will or trust. I don't advise that. I advise 3 copies. I mean, when we're doing them as a law firm, we keep one live copy, give the client one live copy, meaning signatures, and then I advise them to take one copy and leave it off site. I noticed a trend in that when the beneficiaries that are getting not so much in a bequest have access to the house, that the estate planning documents disappear. And I haven't quite figured out why that might be, but I think I have a suspicion. So in a will, you put specific gifts, beneficiaries, and guardians. and you have to have 2 independent witnesses. Everyone seems to think you need to notarize a will. You don't. 2 independent witnesses is what the law says, and they have to both be in the room at the same time and watch the person making the will. Although a notary can be one of the 2 witnesses. A holographic will, they're allowed in California. It's all in your own handwriting. So it's not part this and part that. You do the whole thing in your own handwriting, and it must say that you're intending to make this your will. And the signature on it, you should sign it. It doesn't have to be dated, but you should be. A better method would be to get 2 witnesses. One of the most unusual holographic will stories I've heard was a farmer a tractor fell on him. He was stuck under the tractor and couldn't get up, and he knew he was going to die. So he scratched his will on the belly of the tractor, and it was admitted to probate court. So it may not be worth the paper it's printed on, but if there's something you can read. And I've heard other stories where somebody has scribbled a will on a sheetrock wall, and then when it came down to probate, they take the wall sheetboard off and bring it to court. It just tells. I'm not going to spend a lot of time on holographics because they're fraught with problems. Interlineation. I get clients that ask this. Okay, so I want to change one beneficiary and change the percentages. So they mark it out with their pen and they initial it. Well, they just messed up their estate plan. If you don't follow the same formalities and the same witnesses that the document had, then your interlineation becomes ambiguous and the court's not going to follow it. So I never recommend that. Will notarized, not required. Does have to have 2 witnesses. Did I miss something here? No. Okay, self-proving affidavit. It comes in most wills that says that we saw the person, they were of sound mind, and we were both in the room at the same time and we saw them sign it. And the purpose of that is so that the witnesses don't get called into court to testify, yes, I witnessed the will. Well, this is an example of my will that I had my buddies Warren Buffett and Bill Gates witness for me. They're not beneficiaries of my estate, but this is an example of the self-proving affidavit. A standalone will, you know, I didn't know before I started this that everybody talks about a pour-over will, pour-over will, pour-over will. Well, what do you call the other kind? Well, this is the name, standalone. It's the main part of the estate plan. And then there's a statutory will that's so simple a caveman can do it. And I've included one in the exhibits. It's, you fill out the boxes, you're not supposed to change any of the wording, you're not supposed to write in the margins. You fill it out exactly the way it says, and it came about in statute, the 6240 probate code. And I think it's useful a lot of times. Somebody's going out of the country and they don't have anything and they figure some risk. At least they've got something if they didn't think about it before. And this is the will that most, you know, people are thinking about, pour-over will. And it basically says, here, the will's really perfunctory. It does nominate guardians for minor children if you direct it to. But it says, if you want to know anything about my assets, go read the trust. If the trust is invalid, do what the trust says. It just points back all the time to that trust. There's only a few states that allow the statutory wills, and they're quite outdated. They haven't updated them since about 1980 or something. Wisconsin, Michigan, New Mexico, Maine, and California.
I have a question about the, it says, does independent witness mean unrelated?
Good
I mean,
question.
to ask, not
No, I
related.
got the great question.
Okay.
You do not want to have a beneficiary be a witness, because the assumption there would be their bias. So I use the term independent, meaning non-beneficiary.
Or disinterested.
Yeah, that's independent too. They're not bound financially to the will maker. Okay, oral wills, we talked about those. Electronic wills, only a few states have them right now. California does not have one. I don't recommend trying that at home. Video wills, no state authorizes it. And where I see it is somebody is concerned that they might be considered not competent and not able to have their mental capacity. So they do a video will when they're signing their trust and everything. And it's supposed to support their position. But what happens in practice, it ends up usually proving that they were not competent. So it backfires. Joint wills, that's where two people make out the same will on the same piece of paper. I don't recommend it. It's not a good practice. There's an implication that you cannot change it without permission of the other person. Another one similar is a contract to make a will. Two spouses say, we're going to have a contract, we're both going to do it this way. And then it's not just a will, it's a contract. So it limits your ability to change it. And it causes a lot of disputes. A living will, I really don't like that term when it comes up. And if anybody brings it up, I would change it and not use it. It's not a living will at all. It falls into the category of an advanced healthcare directive. But every so often I hear people talking about it, and all it does is it brings up confusion, and when you're done, there's nothing there. I would bequest to pets. If you give a bequest to a pet, it doesn't go because a pet is property. So it goes to the remainder beneficiaries in the trust or will. California does allow a pet trust. So people have had pet trusts, and you can have one. I would not recommend doing one yourself. I would have an attorney prepare it, but it is permissible and enforceable. Choosing an executor, that's always a big decision, or same with a trustee. Friends, family. I think oftentimes people go friends, family, and then they think institutional trustee or institutional executor. But there's a whole group of people out there called professional fiduciaries now, and they're licensed bonded professionals who act as trustees. And they're just individual people like you and I, and that's what they do. I mean, they act as trustee, they act as guardian, conservators, and executors. You want to make sure that the person you choose is honest, their attention to detail, they can follow directions, and that they're bonded. That protects the assets in the trust. So what's a bond? The probate court here in Contra Costa has a minimum probate bond of $25,000. So that's to protect the asset. It's not to protect the executor or the trustee. It's to protect the assets and the beneficiaries. So we've had them as high as $1 million and up for the bond. And what happens is if the trustee or executor takes the money, then the bonding company goes after the fiduciary and brings an action against them, but reimburses the beneficiaries. And legend has it, they send Dog the Bounty Hunter after the people to bring them in for justice.
You know his wife's dead now, right?
Yes, she died at 55, and I thought that was really surprised to find that out. Now, this is something that is useful. Oftentimes people want to explain why they did certain things. How come I gave this to one person, the other? An ethical will is not a will at all. It can be a document, multimedia file, or whatever you want, YouTube. And what it does is it explains to your beneficiaries certain things why you thought you wanted to distribute your assets. And it's also a way, don't mix it in with a will or trust, because then it really becomes confusing that somebody thinks it was part of a will when it's not. But you can tell what your values are, what you think was important, express appreciation and gratitude for people and things that have happened. And it's a nice explanatory letter that you can give. It's optional, but a lot of people like doing that. It's a way to explain things that maybe you would not have said otherwise. Digital assets, I recommend having all passwords available to the executor or trustee. There is a law that is really not very good right now to have executors and trustees get digital assets, but the big tech companies ignore it all the time. When should you update your will? When you get divorced, when you have a child, when you move to a new state. If you don't update your will when you have a child, the child can later take against the will even though their name is not in there. Things to avoid when you're drafting your own will is what they call precatory language. It's ambiguity. Precatory means I would like you to take care of my pet after I pass away. It didn't say mandatory. I would like if you could sell my house to the neighbor. Didn't say mandatory. And those kind of words like wish, want, recommend, desire, you can do that, but don't think it's enforceable. Your executor can do it or not. Oh, we made it all the way to the conclusion. Got through a lot of the things. Yeah. Well, I do thank you for your time and attention. I am grateful to be able to explain things, and hopefully I help people along the way. I'm learning that not everyone knows everything about estate planning. It's a huge subject. And there's a bunch of puzzle pieces.
So I have a couple more questions before we sign off. Okay. So does the pour-over will also allow for any unaccounted for asset included in the trust, or is a pour-over will provision different than a pour-over will?
What are the two documents? I didn't catch. I heard pour-over will, and then what was the other one?
Does the pour-over will allow for any unaccounted for assets?
Yes.
Included in the trust, or does a pour-over provision different, or is a okay.
Okay. I'll tell you by example. You have a trust and you have a pour-over will, and the person gets a refinance on their house. The bank comes along and says, we don't like them trust things. We're making you put the house in your name before we give you a new loan. And then when the transaction is done, the title company does not put it back in the trust. And when the person dies, it's a probate asset. But the will says no matter what is outside of the trust, I don't care what it is, anything that I own, do what the trust says. And in my example of a house, there's a procedure called the Escheat petition, which was after a case that the probate court allowed the house to be transferred into the trust without a probate because it met all the criteria for a deed. It had a legal description. It had a notary. It had everything that a deed had. So the answer to your question, a pour over will, anything at all that you own, go do what the trust says.
Okay, it's 12 after 7, so I think we need to conclude. Anyone whose question didn't get answered, if Rex is happy to answer them for you if you email the questions to him. So we want to thank everybody for joining us tonight. We'll see you next month, Rex.
Yep, sure enough. It's been
Okay,
fun.
good.
So,
Thank you. Good night.
bye.